And I'm trying to have to get this on the recording. We are going to have a rather quick agenda today. And I want to make sure that we all get here, and I'll announce that we do have a quorum. So we are in good condition. Thank you all for being here on time. Appreciate it. What we're going to do first is have introductions. And we'll all introduce ourselves, everyone that is related to this committee. I'm really pleased to have this committee assembled and also be able to retain our council. And congratulations to our council for a new position. I'm Jim Carlson, and I've just recently been assigned to be the chair of this committee. And I've been on state gov and elections for off and on for several years, been on state government elections in the past majority for 6 years. So I'm happy to say that we have a lot of work to do, and I'm going to have the members introduce themselves. Please do it loudly. Please do tell people who you are, where you represent, and any other pertinent facts to what we do here. So I'll start out with the Vice Chair, Bonnie Westland, Senator Bonnie Westland. So take it away, Bonnie.
Thank you, Mr. Chair. Senator Bonnie Westland. I am representing Senate District 42, which is Plymouth, Medicine Lake, and one precinct of Maple Grove. This is my first term, and it is a great honor and privilege to serve with all of you, and I look forward to our work together.
Thank you, Ms. Westland. And then we'll go to the to the Republican lead, Senator Coran.
Thank you, Mr. Chair. State Senator Mark Coran represents Senate District 28. Mostly Chisago, most of all of Chisago and Isanti counties, probably one of the districts that changed the least in redistricting. And so this is my 6th year, my third term. I served on state government elections each of the last 6 years, and so looking forward to being here. Thank you, Mr. Chair.
Thank you, Senator Grant. And now we'll start with the members, starting with one of our senior members, Senator Limmer.
I'm really beginning to wonder why everyone calls me the senior member. I'm Warren Limmer. I represent the city of Maple Grove, most of it. Bonnie Westland shares one precinct out of it. And then I also represent a number of cities in west central Hennepin County, going out to the Wright County line.
And Senator Swedzinski.
Thank you, Mr. Chair. Steve Swedzinski, Eden Prairie, Minnetonka. Looking forward to this committee greatly. I served 1 year, I think, or two on when it was state, local, and elections, and loved every minute of it. It's very informative and insightful and thought-provoking committee to serve on. Thanks,
Thank
Chair.
you, Senator Swedzinski. And Senator, I'm sorry. Senator Dornick. I was just kind of taken back by Senator Swedzinski using a microphone. He usually doesn't need one.
It's for the tape.
Thank you, Mr. Chair. My name is Gene Dornick, serve District 23. The bigger cities are Austin, Elberly, and Wells. This is my 2nd term, and look forward to serving on the election committee. Thank you, Mr. Chair.
Thank you, Senator Dornick. Senator Anderson.
Thank you, Mr. Chair. Senator Bruce Anderson, represent the Senate District 29, which encompasses a little bit of Hennepin County and Rockford, the city of Rockford, all the way across the county of Wright, and then a little bit of Meeker County, Kingston Township. This is my 4th term in the Senate, and the last time I think I served on elections in state and local government, it was when I was back in the Minnesota House. So looking forward to see what the new issues are for coming up. Thank you.
Thank you, Senator Anderson. And we'll go to members on the other end of the table, starting with Senator Mitchell.
Thank you, Chair. I'm Senator Nicole Mitchell from District 47, which is part of Maplewood and all of Woodbury. And I consider myself an election nerd. I've been an election judge since 2018, so helping people register and vote, and I just think it's so important. So I'm really, really glad to be here. Thank you.
Thank you, Senator Mitchell. Senator Bolden.
Thank you, Mr. Chair. I am Senator Liz Bolden. I represent District 25, which is much of Rochester, Orinoco, and surrounding areas. This is my first term in the Senate. I served one term in the House, and very excited to be doing the work on this committee.
Thank you, Senator Bolden. Senator Matthews.
Thank you, Mr. Chair. Andrew Matthews, represent Senate District 27 now. I'm from Princeton. I represent most of Sherburne County except for Elk River and the St. Cloud corner, and then pieces of Mille Lacs, Isanti, and Anoka counties. So Princeton, Zimmerman, St. Francis, Becker, Big Lake, Clear Lake. And this is my third term in the legislature, and looking forward to working with you all on the committee.
Thank you, Senator Matthews. Senator Rest.
Thank you. Senator Matthews sits so tall. He really does. I want to sit that tall. Anyway, Ann Rest from New Hope, District 43.
Thank you, Senator Rest. Senator Port.
Thank you, Mr. Chair. I'm Senator Lindsay Port. I represent District 55, which is Burnsville and Savage. This is my second term in the legislature, but my first serving on elections. I look forward to working with you all.
Thank you, Senator Port, and I hope that you do take care of the constituents that you have took over from me.
I appreciate that area, Mr. Chair.
Thank you, Senator Port. And Senator Barr.
Thank you, Mr. Chair. Senator Barr, Senate District 31, runs from Ramsey up through Linwood Township, kind of an east-west diagonal there, northern chunk of Anoka County, and I stole one township from Senator Curran. 6 years in the House, so I'm looking forward to the things the committee has to offer. Election integrity is kind of important to everybody.
Yes. Thank you, Senator Barr. And now what we'll do is we'll go to staff, and I'll start over here with Taylor Spreeman.
Okay. I'm Taylor Spreeman. I am the committee legislative assistant, and I work with Senator Jim Carlson. I've been working with him since September of 2021, so I'm really excited to be helping out in this committee.
Thank you, Taylor. Go ahead.
Mr. Chair and members, I'm Beth Fraser, and I'm serving as the committee administrator.
Beth Fraser was at one time the Deputy Secretary of State, and known her as one of the people that has the best information on elections that anyone can possibly have, other than maybe the Secretary of State. So bringing the pressure heavily on her. So let's go to Mr. Andrews.
Thank you, Mr. Chair. Andrew Erickson, I'm the fiscal analyst for the committee. I've been with Senate Council for 6 years, and I also cover state government.
Thank you. And Ms. Stengel.
Thank you, Lexi Stengel, Senate Council, handling areas of election and also meeting your transportation needs if you have any of those.
And Ms. Stengel is one of the people that has been very adept at explaining all of the ins and outs of our election systems, and we're going to be relying heavily on her as we get through this session. Okay, then we have some committee pages, and I want you to make sure that you realize that committee pages are the real workhorses here. When you need something delivered to you, they will probably deliver it. They will be around, largely seated over in the little alcove over there. And let's have a wave from Morgan Turner and from Ileana Sundarup. Ileana Sundarup. Okay. I got the first name close. Okay, and like I say, there will be the people that distribute the bills and information on the back table. And always remember that you can go to the back table and get information that we're contemplating up here, as well as amendments. So any questions from anyone on these details? Anyone from the committee? Any questions? Okay, so we're starting off this year. Sorry, do we have a? Oh, Senator Marty. Senator Marty, we have just introduced almost everybody except you. And you have your place down at the end there. Senator John Marty has the distinction of being I think you're the longest serving senator now, and even one of the youngest. So we'll have him introduce himself, and then we'll get started.
John Marty, and glad to be on this committee again, and a lot of good work we can do here. I think it's the biggest committee in the Senate, by the way.
Yes. Yes, thank you, Senator Marty, and yes, it is the largest that I'm aware of, and which brings up some of a priority that we'll need to honor, and that is we need to be efficient. Please, if you have something to say, members, say it, and blessed are those who have little to say and cannot be convinced to say it. So let's make sure that we're quick and that we get our points out quickly, and then let the others speak as well. So today we're going to be hearing from the Campaign Finance Board, and just want to say again that I'm excited to work with all of you, excited to work on these subjects. The state of Minnesota was so kind as to deliver the majority to the people that are sitting up here. And what they said is that they wanted democracy to be protected. And so that's our mantra here, is we need to be sure that we protect democracy. And I'm going to say one more thing here, that I want to make sure that we hear the ideas from all people. So one of the things that I have been both credited with and criticized for is I want to make sure that we are as bipartisan as we can be. And what I will ask of you is, if you have bills, please try to get someone from the other side of the aisle to be one of your co-sponsors. If you cannot, I'd like that you maybe reserve one of the 5 sign-up blanks to be for a co-sponsor that's from the other side. And what we will be doing is we'll be looking at, and obviously the chair and the committee people will decide what bills will be heard when. And so having someone from the other side gets rid of some of the first conversations, the first arguments, the first disagreements, and we can get them improved then. So if we can, we want to make sure that you get somebody from the other side of the aisle, and that goes for both the Democrats and the Republicans. And if you can't, have a blank. I want to especially congratulate Senator Port for doing exactly that. She has a bill and she has someone from the other side of the aisle, and that meets that criteria. So what we're going to do is we push that up to have a higher priority of being heard. So that's what we're going to do, is make sure that we hear those bills that have a higher chance of getting to be law and have some bipartisan support. So with that, I'm going to also make just a brief comment here that we did have an anniversary that we're not happy with, and that was the anniversary of the January 6th insurrection. And some of that is probably due to some of the election disagreements we've had. And we want to make sure that our election officials are respected. Our election officials are honored, because these are people that are our friends, our neighbors, and in some cases our relatives, wives and husbands. So we want to make sure that we honor those people, so that, first of all, so that we can recruit more of them, and also so that they feel that they're comfortable in serving in that position. So let's move along here. We will start out by having Mr. Jeff Sigurdson give us a rundown of the, I'm sorry. Oh, I'm sorry. Yeah, we're going to have the nonpartisan presentations first, and that's with Mr. Erickson on our fiscal analyst, who will give us the coverage that he's providing for us.
Thank you, Mr. Chair. It's just a very brief run through. The jurisdiction encompasses just a couple of pieces. The Campaign Finance and Public Disclosure Board's base budget is in the elections area, as are any election-related change items at the Secretary of State's office. For now, there's a spreadsheet that is published to the web, and the only thing that is included on there for now is the presidential primary open appropriation, but that will soon be populated, I'm sure, by change items from the Secretary of State and whatever this committee chooses to move forward with. Thanks, Mr. Chair.
Thank you, Mr. Erickson. And now we go on to our Senate Counsel. Ms. Stangl will give us the rundown of what jurisdictions we have.
Thank you, Mr. Chair and members. This committee has jurisdiction over all bills relating to elections, including the portion of the Secretary of State's office that works on election administration, but that also includes anything else having to do with relating to elections. It includes jurisdiction over any redistricting issues that might come up, as well as ethical practices for public officials and anything having to do with campaign finance. The other thing I would note is that this committee has jurisdiction over confirming the Campaign Finance Disclosure Board members.
Thank you, Ms. Stangl. Okay, now we can go ahead to Mr. Sigurdson and his presentation on the Campaign Finance and Public Disclosure Board.
Thank you, Mr. Chair. Good afternoon, committee members. My name is Jeff Sigurdson. I'm the Executive Director of the Campaign
Mr. Sigurdson, can you get a little closer to the mic, please?
There we go. I'm the Executive Director of the Campaign Finance and Public Disclosure Board. Just a brief background, I joined the state in 2012 in the Elections Division of the Secretary of State's office. I moved to the Campaign Finance Board in 2000, and then became Executive Director in 2016. Also with me today is Megan Engelhardt. She's the Assistant Executive Director with the board, and there may be circumstances where if there's questions for the board and a presentation is necessary that she will be before your committee. In some ways, I'm always unsure of how much time to spend talking about the board because as elected officials and public officials, you're very much aware of two of the programs that the board administers, and you interact with the third program. All three of the programs are basically to promote public confidence in government decision-making. We start with providing disclosure on the funding of candidates and political party units and political committees through the Campaign Finance Program so that people understand the source of funds used to conduct elections in Minnesota. Then we move to the Economic Interest Statement Program, which is where all public officials list their investments in real properties so that there can be at least a base of knowledge. So if there's any doubts about a conflict of interest that may come before a public official as they look at their official actions or have a vote coming up, the public can be aware of any potential conflict. And then the third program is the lobbying program, which of course you interact with on a daily basis. The board itself is a quasi-judicial board. We're limited to civil penalties. We can refer potential criminal matters, but we have no jurisdiction over criminal matters. Because of the potential for damage to public officials, the reputation, and also, frankly, the potential to influence an election, the board is very careful in its investigations and follows a pattern that's provided in statute. It's a three-part, three-step process. If a complaint comes in, there's a prima facie determination to find out if it even is within the board's jurisdiction. There's a probable cause determination, which I'm going to talk about a little bit more later on in recommendations from the board. That is the first opportunity for the individual or committee that has an allegation made about it, that it can make its defense to the board, it can appear before the board and explain why the allegation is false. And then after probable cause, if the board believes that an investigation is necessary, then we move on to findings or a conciliation agreement to cure a violation. That process, again, is very much, I believe, weighted towards the individual or association that is facing an allegation. And that's why sometimes it's frustrating that the board isn't moving faster. but the board always wants to give enough time for the entity that's being, again, facing an allegation to prepare a defense, hire legal counsel if they need to do so, and present their best arguments as to why the allegations are false. The staff review of reports is another way that the board enforces the provisions of Chapter 10A. That's when we just look at the reports. In fact, most of the violations of Chapter 10A, when we're talking about excess contributions or special source violations, taking a contribution during the legislative session, those are usually actually self-reported. And we see those on the reports that come into the board, and we can have authority then to clear those through a conciliation agreement. But the other important issue here is disclosure. Everything that we receive in terms of reports and all of the investigations that we conduct eventually end up on our website. So do all the economic interest statements that you file as public officials, so do all the lobbyist reports. Basically, if it's filed with us, it's on our website. And that does allow, again, people and the media to have a source that they can go to and quickly get access to information that will hopefully provide disclosure on the issues that are important to the public. The board is an independent agency. The governor includes our request for budget in their overall budget, but we do not report to the governor's office. The board consists of 6 members, no more of half of which can be from any political party, and at least 2 members must be former legislators, 1 for each party. We have currently 8 full-time staff members. We are in the Centennial Office building in Suite 190, which is on the tunnel system. If you ever want to come by and have a conversation about an issue that you're facing, we're happy to have those conversations. The office is open.
Mr. Sigurdson, I have a question.
Yes, sir.
And by the way, I want to make mention to folks here that Mr. Sigurdson said that you should ask questions as they come up in your mind, so he's willing to take questions from the audience. But my question is, when you talked on that last slide, you talked about no more than half, which may be from one party, and at least 2 members must be former legislators, 1 from each party. Are we assuming 2 parties? Is there something that is now changed with another party being a major party?
Mr. Chair, there isn't a requirement that the individuals appointed to the board by the governor have to be with a major party. And also going back further, Governor Ventura appointed 2 members from the Independence Party. So it's not required that it's DFL and Republican Party members only, and we have also had in the past members who have no party affiliation. Relatively rare in both cases, but it can occur.
Okay, thank you.
Speaking of confirmation hearings, we do have 2 members who will be up before you sometime this year. The former DFL legislator is Senator Flynn. Her position expired on January 1st, and the governor is considering who to appoint to that position. And the other position that's open is also a DFL member position, or at least is currently a DFL member position. This is one of, I think, only 2 agencies where confirmation is required in both the House and the Senate. Sometimes that does become a little bit of a timing issue, but the governor has not made any appointments here, but obviously as soon as they do, we'll be trying to schedule a hearing as soon as possible. Just briefly on the campaign finance program, just to give you a little bit of information so you have some information on scale. We're state level offices only. We currently have about 700 candidates registered with the board. We have about 320 political party units, 75 independent expenditure committees and funds, and about 350 what I would call regular political committees and funds. The difference there is an independent expenditure committee and fund can take corporate contributions but only make independent expenditures, as opposed to the more, I guess, common political committees and funds, which can make independent expenditures, but because they can't take corporate contributions, can also make contributions directly to candidates. We view training and client support as extremely key. Frankly, in this state, almost all treasurers are volunteers. We think volunteers are sort of volunteer treasurers are sort of the key to making this work. I think in most cases they sign on and don't realize what they've signed on to until it's too late. So we try to provide them with lots of training, both both in the evening. We record our training sessions, so if it's not convenient for them to come to a training session or be on a live training session, that they can at least play back the recording. And we try to, again, support the treasurers in any way that we can. I did want to point out, as you've been all working with our campaign finance reporter software, which is PC-based. It was originally developed in 1998. It's pretty obsolete. We've been working for the last couple of years to develop a online version of that so that we can get away from the problem of not running on an Apple PC or a Chrome PC. Instead, it'll be all online. That is actually complete, at least in its first version, and we had, I believe, 6 committees that were sort of our under the radar beta testers for this last election. We decided, frankly, it was too much for us to roll that out during a state election, but we did have some committees file all their reports using the online system, and we're comfortable enough that we will be rolling that out and moving all committees to that in 2023. Briefly on the public subsidy program, which we administer in 2022, we paid out $2,348,000 to 316 constitutional and legislative candidates. The number of candidates who are signing the public subsidy agreement is in slow decline. It used to be about 95, 96% when I first joined the board. We're now down to 89%. I realize that's not a super steep decline, but we do see candidates starting to back away from the public subsidy program. It does also, of course, provide access to the political contribution refund program. In 2020, which is the last election year that I have numbers for, $1,326,000 in contributions to candidates was refunded by the Department of Revenue, and a little bit over $2,190,000 was refunded for donations to political party units. For candidates, that's particularly important because about 30% of the donations that candidates received from individuals was refunded by the Department of Revenue. The board does have authority in Chapter 10A to bring to the legislature recommendations on how to improve the program. And there's a number of them here, which I've listed. I'll go through very briefly, and then, as the chair mentioned, I'm happy to take any questions. The definition of independent expenditure has been an issue for the board for quite some time. Currently, to be an independent expenditure, you have to use what's called express advocacy, which are also sometimes referred to as the magic words. This is going back to a Supreme Court decision that said if you use words like vote for, re-elect, defeat, those are expressly advocating for someone's election or defeat, and so that can be viewed as an independent expenditure. Over time, the Supreme Court changed that definition and said, okay, you can use express advocacy, but you can also use what's called a functional equivalent. And a functional equivalent is language that really has no other possible meaning than other trying to influence the nomination or election of a candidate. Again, the U.S. Supreme Court has provided that functional equivalent can be used as a standard, and the board has seen cases where advertisements were sent out, mailings were made that were not, could not be viewed as independent expenditures because they didn't use words of express advocacy, but there wasn't really much doubt as what was trying to be achieved here. I mean, if you call a sitting legislature a liar and say other things about their role, but never say vote against, then that means that you can't be regulated. You're not required to provide any disclosure as to the source of your funding or even to the number of expenditures that you made. And the board doesn't believe that's fair. On one hand, you have people who are providing full disclosure to the public, and then you have others who are not. And this is just trying to make it more of an equal playing field so that we have complete disclosure of the expenditures that are trying to influence elections in Minnesota. The second is on the issue of cryptocurrency, bitcoins. There isn't anything in Chapter 10A dealing with that. And right now, if a candidate receives or a party unit receives a contribution that's in cryptocurrency, the question is, well, now what do we do with it? That's very volatile, and what the board is recommending is not to prohibit that. That's fine. You can receive the contribution, but it needs to be converted into U.S. currency and deposited in the committee's account within 5 days. Otherwise, that volatility has the potential to cause violations that weren't intended when the contribution was made. For example, if you get a $1,000 contribution in cryptocurrency, you don't convert it for, say, a month, and now it's worth $2,000, does that mean that you've accepted a contribution that's in excess of the limit? 10A doesn't really talk about that. So that's something that, again, we're not trying to prohibit the use of cryptocurrency for contributions, but we're providing a process here to move it into the committee quickly so as we can avoid those issues. The next is the issue of fair booths at the county and state fair and other community events. You often see fair booths for both parties, and often on those booths you'll see a big display of literature, for obviously for the local legislator, for the governor, for federal office. The problem is that currently under Chapter 10A, those are all contributions to those candidates. And so somehow the local party unit treasurer is supposed to look at that table and say, okay, 6% was for this senator, 14% was for the governor, and then report that as a contribution. And nobody does that. So what the board is suggesting is that we move this to the multi-candidate political party expenditure category. You may be most familiar with that category because of the sample ballot, the official party sample ballot. As long as it lists 3 or more candidates, that's not considered a contribution to any candidate. The candidates don't have to disclose that or count that as a contribution. This would do the same thing. Basically, if the fair booth is displaying the information or is being used by 3 or more candidates, then it's considered one of these multi-candidate political party expenditures, and it doesn't have to be recorded and somehow reported by, again, volunteer treasurers who are certainly not aware of that requirement. We are moving a couple of things into the non-campaign disbursement category, which you recall doesn't count against your spending limit. One is recount costs. The board does have the authority to basically recognize a non-campaign disbursement that isn't in statute through an advisory opinion, but if it wants it to be, if the board wants it to be more widely used or widely available to candidates, it needs to move it into statute or administrative rule. And that's what we're doing here. We think that recount costs, the election's over, it shouldn't count against the spending limit. It's reasonable to say that you can use whatever funds you still have in your committee to help bear the cost of a recount. And so that's just moving it into the list in statute so that it's available to all candidates. Another one that we have is the transitional office for constitutional candidates, again, as a new non-campaign disbursement. It doesn't really apply this year, but in the past, when we've had a new governor, they have the same situation. They hire, in some cases, literally over 100 people. And the Attorney General doesn't hire 100, but hires dozens of people. And they don't want to wait until they're sworn in office on January 3rd. They want to get a running start as soon as the results are clear. And frankly, if you're a winning candidate for governor, you don't have any problem raising funds, but you're usually already going to be at your spending limit. So what this is saying is that, fine, this is a non-campaign disbursement. You're not trying to influence the election. The election's already over, but we'll recognize you using committee funds to set up an office where you can start doing your interviews and setting up so that you can get a running start as soon as January 3rd comes around. The last is a little bit more controversial because, frankly, it's outside of Chapter 10A. Right now, the PCR limit is $50 per person, $100 per couple. The board has noticed that the amount of PCR contributions being issued is going down. Participation in the program is going down. And one way of perhaps raising interest in it would be to raise the maximum contribution that can be refunded from $50 an individual up to $200 per individual per year. I do recognize, and again, we'll acknowledge that that's not Chapter 10A, that's Chapter 290, which is the Department of Revenue. But the board at least wants to have the legislature aware that that program is in decline, and it might be something to at least consider. And Mr. Chair, could I pause for a moment and just say, before I go into the economic interest statement program, if there is any questions on those recommendations? If not,
I have one question. When you Mr. Sigurdsson, when you talk about decline of that system that is existing, does that mean that, for instance, tax form checkoffs get distributed to a smaller number of people, so it's a larger distribution to the people that are still taking advantage of it?
Mr. Chair, no, sir, not really. Those are two different programs. The tax form is where you check off $5 that's then dedicated to the public subsidy program. The PCR program is where you can give up to $50. Well, you can give more than $50, but the first $50 that you give to a candidate or party unit, you can give a PCR receipt. This is for candidates that have signed the public subsidy agreement or to any political party unit. And then the donor takes that to the Department of Revenue and can get up to $50 back. The amount of money that's being refunded through the Department of Revenue has gone down dramatically. It used to be, again, $6 or $7 million during an election year was refunded to contributors. It's down now, as I mentioned earlier, maybe to $3 million. I think part of that, there's various reasons. I think, people unfortunately aren't when I say people, I mean donors perhaps aren't looking to be part of that program as much. But I also have noticed that there no longer is much interest in promoting that program. For example, at one time, the Republican Party made a large push about, here's your opportunity to make a contribution, and here is the process for getting your $50 back. I don't think that the $50 is seen to be as valuable as it used to be in terms of pushing for that type of refund. And if it's raised up to a higher level, maybe $200, then it might make it more attractive to candidates and political parties to try to push forward that program. And again, maybe I didn't say this very well, but the reason that the board thinks there's a benefit to that is that, remember, the PCR program is only available to individuals who are residents of the state of Minnesota. So if you want to increase the amount of funding for political campaigns that are coming from Minnesota residents, this is the way to do it. It decreases the hopefully will decrease the amount of money that you need to raise from political committees, which may or may not be based in Minnesota. So this is just one approach for trying to do that.
Okay, thank you. We have a question from Senator Swedzinski.
Thank you, Mr. Chair. I just have two questions as well. I'm just curious about if you can give a 2-minute tutorial on the history of the PCR program. I have no idea how long it's been around. I don't know what the original intent of the program was. And I know there's probably a good hour lecture there, but if you could do a quick 2-minute historical analysis of it. And then I'm just curious about where's the budget for the PCR program? I mean, there must be during presidential years it goes up, and then non-presidential years it goes down. Where's that surplus kept of unspent money? I have no idea where, and I don't want to get stuck in the weeds on our first day, but I'm just so curious about where that budget is in the grand scheme of things. Thank you, Mr. Chair.
Mr. Sigurdsson.
Mr. Chair, Senator, to your second question, first, it's an open appropriation. When you look at the appropriation that usually comes out of this committee, as long as it isn't capped or isn't as eliminated, and there have been years in which the PCR program was shut down. The unallotment years during the Pawlenty administration, I'm sorry, I'm not going to be able to come up with the 2 years that occurred. The PCR program was one of the things that was unallotted, so it was shut down. But otherwise, it's an open appropriation. There is no cap. Just whatever money the Department of Revenue needs to make the refunds, it has access to. In terms of the primary purpose, I think it goes back to my understanding, at least, and this is prior to me joining the board, but it's always been explained to me that, again, it was a way of trying to increase the number of donations that came from Minnesota residents, Minnesota residents, as opposed to relying on political committees, even relying on party units. There was this mechanism here that would help you get money from individuals who hopefully lived in your district, but certainly lived within the state, and this was the way to try to promote that. The third question about what year it first came into play, I'm going to have to go back and look. I, in fact, the board does have a report on the use of the PCR program over the years. I want to say 78 or 79, but I apologize, I might be off by a year or two. But I'll send you a copy of that report, sir.
Follow up? Yep. I think, did we have Senator Barr first? Okay. Okay. Senator Cran.
Thank you, Mr. Chair and Mr. Sigurdson. I know it's old. I was at the Department of Revenue when the PCR program, when we were looking at how to automate it. So I can appreciate all of the legislative recommendations, and I think they all make sense, except for the last one in regards to I think you're covering it in the intent of raising the contributions through the PCR. I'm not sure that we appreciate it as legislators, but I'm not sure that it's the role of the Campaign Finance Board to suggest that. But when we look at the dollar amounts, it looks like, it's waning. And I think we've carried multiple bills before, and you've seen them, to maybe it's so little interest, maybe it's time we get rid of the PCR publicly funding of elections. So, so we appreciate the suggestions, but I think it's our job to go out as elected officials and go out and find that campaign dollar and make sure and compete hard for it and get the interest in there. So we do appreciate it. So thank you.
Mr. Sigurdson, response?
Was there a question from Senator Crane? I mean, the only thing I would say, Mr. Chair, Senator, as I probably acknowledge or hope to acknowledge at the beginning, is that the board recognizes that this is outside of Chapter 10A. So we're aware of that.
Thank you.
Mr. Sigurdson, follow up with that. Do you track internal Minnesota contributions versus external?
Mr. Chair, no, sir, we don't, but for itemized contributions, that would be relatively easy to do because we do have the address of any itemized contribution.
Okay. Thank you. So there's no normal reporting of that or logging of that the public can see?
Mr. Chair, no, sir, there isn't. Again, frankly, that'd be a simple query. I can send information to you on that, at least for we haven't received the year-end reports for 2022, but certainly for prior years, I could send you some information on that.
Thank you. Any other questions? Senator Barr.
Thank you, Mr. Chair. Mr. Sigurdson, I'm kind of curious with the PCR. I'm going to assume that there's more money going into campaigns every year. Is that a safe assumption? Okay.
Yes,
with that assumption, then can you see like a movement or a correlation with less money going into PCR and maybe into 501s or 401c3s or C4s, money that way that's spent kind of outside of the like IE expenditures? Do you see money moving that direction? Would that affect the limit? If we could give $200 to a candidate, then I give 50 to a candidate now and I give 150 to an IE. You could be any of the IEs, any of the different 401s, 401c3s, right? 501c3s, sorry. But at the outside expenditure groups, does that make any sense? Does that correlate at all? Like the outside expenditures are going up and you're seeing PCR go down, but yet the overall money is kind of on the same trajectory?
Mr. Sigurdson.
Mr. Chair, Senator Barr, I would say no for this reason. The majority of funding that goes into the independent expenditure committees and funds comes for 501c4s that are not based in Minnesota. So it's unlikely that the majority of their funding is coming from Minnesota residents.
Follow up? Okay, thank you. Any other questions? Okay. Mr. Sigurdson, please.
Moving on to the economic interest statement program. As you know, as I already mentioned, this is the program where you disclose possible conflicts of interest where public officials make an official action. This is done through the declaration of sources of income, your employment investments, certain property holdings that aren't homesteaded, and the nature of businesses owned. I will point out that this is a lot more than just the legislature. There are over 3,000 public officials who file documents with the board. I'm a public official. Anyone who works for an agency in certain positions that has the authority to make administrative rules are public officials. All county commissioners are public officials who file with the board. All judges are public officials who file with the board. So there's a long list. And again, at the end of January, you've hopefully received your letter, is the annual certification of the economic interest statement where you provide information on the holdings that you had in 2022. There are recommendations here. One is trying to address a problem that came into play when the Soil and Water District Conservation Supervisors and Watershed Management Organization members were moved into this program. They weren't always required to file economic interest statements, but they now also file with the board. There's about 880, I believe, of those individuals that do. They don't file that statement. When you file for office, you may recall that you get an economic interest statement that you have to file within 14 days of filing for office. That doesn't apply to Soil and Water Conservation District members. They only file that document if they win the election, so they file it in January. The point comes is that, frankly, they are often not aware of that requirement when they file for office. It's a $20 filing fee, I believe, to run for Soil and Water District Supervisors. They are very surprised at the type of information that they need to provide to St. Paul. And in many cases, well, I shouldn't say many, but certainly in a number of cases, individuals have resigned on the spot rather than fill out the economic interest statement. The board believes that there might be a way to try to address that Soil and Water Conservation District Supervisors have rather limited authority in their official actions. It's limited to a particular watershed. I'm not saying I'm an expert on it, but from my understanding, they're limited to basically drainage issues. It's unlikely that they're going to see an issue that reflects or is somehow going to be in conflict with owning stock in Ford Motor Company. So there is, the board's proposal is that they still have to file an economic interest statement, but it would focus on real property owned by that individual that may in fact be influenced by an action that they take as a Soil and Water Conservation District Supervisor, and moves away from information on the type of investments that they couldn't influence because of the limited authority of the position that they hold. Hopefully that would allow more people to be comfortable as serving as Soil and Water Conservation Districts and watershed management members. There are two, in the board's perception, there are two loopholes or at least areas where the disclosure can be improved. One is that currently, if you're a public official that serves on an agency that dispenses professional licenses, contracts, or permits, and you receive one of those licenses, permits, or contracts from the agency that you serve on, you don't have to disclose that. This would change that. If you're in a position where you're voting on whether or not you or a business that you own at least 25% in is going to receive a contract from a government agency, you have to disclose that so that there's this going to be upfront information on whether or not that's a conflict of interest. The third point is one that, frankly, you've perhaps seen before if you've been on this committee before. The board does believe that, well, let me step back. Currently on your disclosure statement, you provide information on any investments, again, property, non-homesteaded property, that you own as a public official or that you own jointly with your spouse. There's no information required for those sort of investments that are owned entirely by your spouse. The board believes it's possible to have a conflict of interest even if the farmland or business is owned by the spouse. The public official is still going to be aware of that, and that may cause a conflict of interest that the public should be aware of. A variation of that is whether or not that should be expanded or extended to not only spouses but to domestic partners. You know, that's a more difficult question. Domestic partner is not a defined term that I can find in Minnesota statutes, and I don't mean just Chapter 10A, I mean anywhere. So that may be a bridge too far, but at least the issue of providing disclosure on investments held by a spouse, because there would be, in my understanding, there would be a legal right for the public official to have a percentage of any income earned by that investment owned by the spouse, is something that the public should be aware of. And again, I'll just wait for a moment, Mr. Chair. That's the economic interest recommendations.
Any questions, members? Oh, we have one from Senator Limmer.
Thank you, Mr. Chairman. Mr. Sigurdson, do we require economic interest statements from city officials or county officials that are elected?
Mr. Sigurdson.
Mr. Chair, Senator Limmer, the answer is sometimes. All county commissioners are required to file an economic interest statement with the board. Individuals who are elected at the county level sheriff, attorney, county attorney. They don't file with the board, but they file with their local county. In the metro area, for cities with a population of greater than 50,000, those individuals, and this is in the metro area, those individuals also have to file an economic interest statement, but they're filed with the city. The thought being that it's easier for individuals to both file that way and also to, for the public to have access. It's not only elected officials, city council, mayor, it's also anyone identified by that city as having significant authority over budgets. So for example, usually the finance director for the city, the police chief, et cetera, is going to have to file an economic interest statement. But again, that's only for the metro area cities.
Mr. Chairman, is there a violation or a penalty for not disclosing economic gain by a candidate?
Mr. Sigurdson.
Mr. Chair, Senator, I'm sorry, I'm not sure if I'm following your question, sir. If they don't file an economic...
Let me reword it. Is there a penalty for failing to disclose economic advantage, or not advantage, but economic gain? Is there a penalty for not doing that?
Mr. Chair,
Sigurdson.
sorry, Mr. Chair, Senator Limmer, I think there would be in two different ways. First, there's a relatively minor penalty, just to quickly mention, for filing it late, but that's a relatively minor late filing fee. But when you file the economic interest statement at the bottom, you are certifying that it's a true and complete report to the best of your knowledge, with a $3,000 fine for false certification. So that would be available if a board investigation found that information had been deliberately left off a form.
Yeah. I guess, Mr. Chairman, I guess I'm more concerned about the smaller offices, the political subdivisions, and how they handle that. Even if the cities were smaller than a 50,000 population. I don't understand the reasoning why we ask one candidate to fill out an economic interest statement and not another one simply because of the population of their city. Is there any history that you can disclose of why we drew that line?
Mr. Sigurdson.
Mr. Chair, Senator Limmer, I think it goes back, I don't want this to sound too sarcastic, but I think it goes back to the idea that the smaller cities don't have this problem. I think it's not only in the economic interest statement program that has this sort of strange division of where it has to be a city over a certain limit, and the city has to be in the metro area. For example, Duluth and Rochester aren't covered at all. But it should be pointed out that this same issue is in the lobbying program. The lobbying program for lobbying of local officials applies only to the metro county and only for county level officials, but for only certain cities. So there has been always the belief that I believe that very small communities or smaller communities somehow don't have this problem, or at least it isn't worth the effort to monitor and enforce. But all of that, frankly, was in place prior to me joining the board. I'm not sure I can answer it beyond that's my understanding.
Follow-up? Thank you. Thank you, Mr. Sigurdson. Senator Matthews.
Thank you, Mr. Chair. And on a similar note, excuse me, on a similar note, both with you talked about how there are certain categories of economic interest that's filed at a local county instead of with the state. And it made me think back to, I believe there are some types of campaign categories that do something similar, that rather than like me as a legislative candidate with a campaign finance account that I report to, some are filed at a county level or such. Are there, to your knowledge, are there the availability to find those reports as easily as through the statewide campaign finance, or do you run into difficulty of maybe for some of these smaller counties or smaller municipalities that the information might be harder to find than for our state candidates?
Mr. Sigurdson.
Mr. Chair, Senator Matthews, you're correct, sir. If you're running for any city office, regardless of the size of the city, you file not under Chapter 10A, which is the chapter that you file. You file under 211A. And that, those reports are filed locally. If you're running for county office, you file with the county auditor or the equivalent of the county auditor. If you file for city office or school district office, you file with the city clerk or school district clerk. There is a requirement that those cities and counties and school districts that have a website that post those 211A reports have to provide us with a link to that. And if you go to our website, there is a page where we have, on the top of my head, I don't know, I'm sure all 87 counties, not all cities, not all school districts, listed there. And if you click on a link, you'll go to their page and there's their reports for their candidates. I would say that the reports for Chapter 211A are brief. They're basically a one-page report. So there is a difference in the detail required for municipal and local level officials.
Follow-up? Thank you. Okay, I think we can proceed.
Thank you. The last program I'd like to touch on is the lobbying program. Again, the idea here is that there's never a limit on the amount of lobbying. In fact, there's no registration fee if you wish to be a lobbyist in Minnesota. We have about 1,450 lobbyists registered. They represent about 1,500 lobbyist principal. A principal is simply an association that's hired a lobbyist to be represented in Minnesota. Registration is required for compensation of over $3,000 a year from all sources to communicate to influence official actions or urging others to contact public officials. What I'm trying to say there is that lobbying basically is being paid to have a conversation with a public official to try to influence their official actions. It's not the citizen who has an issue that they want to talk to you because they're not being paid for that activity. It's people who are being paid for that. The types of lobbying, there's the legislative process, which you're of course aware of. That includes actions by the governor. There's administrative rules, which is when an agency adopts administrative rules. That's a lobbying process. So if anyone's trying to influence the administrative rules, they have to check a box. Actions of the Public Utilities Commission in terms of rate setting or line setting or plant setting is also covered by this. And then the last, which we mentioned somewhat, the metropolitan area governmental units, that's the 7 counties. Currently, there are 16 cities within that area that are covered by the lobbying provisions, and also the Met Council and the MAC are counted as entities that would be lobbying under Chapter 10A. The problem with the program, and quickly, I'm sorry, another information screen. There is, of course, the gift prohibition. That's part of the lobbying program. Lobbyists report twice a year, principals once a year. The principals in 2021 reported $73,800,000 as the amount they spent to influence public officials in Minnesota during that year. The problem with the lobbying program from the board's perspective is that the emphasis on what's being disclosed to the public is the administrative cost of lobbying. There's a category for the lobbyists to determine how much of their cell phone bill goes to each of their clients, how much of their office space should be allocated to each of their clients, how much of their administrative support goes for each of their clients. In discussions with the Minnesota Government Relations Council, the MGRC, I think, I'm very reluctant to speak for them, but I think there's an agreement on the with the regulated community and with the board that disclosure doesn't get us anywhere. You can't tell what entities are interested in what subjects, what they're actually trying to do in terms of influencing public policy by looking at their cell phone bill. We're not, knowing that they paid $60 to AT&T just doesn't get you very far. So the board's recommendation is frankly a start from the top and work its way through proposal on lobbying that totally changes the type of disclosure that we receive from lobbyists. Now, currently, if you lobby anything that's in the metropolitan area, you simply check a box and say, yep, I lobby in the metro area. You never say which of the counties, which of the cities, the MAC, the Met Council, and you certainly don't say the topic. Under this proposal, you would have to say, for example, for my client, I lobbied the city of Minneapolis on rent control. If you did St. Paul on the Ford plant, Ramsey County on fill in the blank. So there, for the first time, would be, I think, meaningful disclosure on the type of issues that these individuals are trying, that lobbyists are trying to influence. Same goes with the Public Utilities Commission. Currently, you don't even check a box saying that you're trying to influence the PUC. Now you'd have to say, okay, this past year I worked on the Public Utilities Commission, and here are the specific projects before the rate increases or whatever the issue may be before the PUC that I was lobbying on. Administrative lobbying, currently you just check a box saying I'm doing administrative lobbying. Under this proposal, you would say Department of Health, this particular administrative rule, here's the revisor number, so that, again, we can drill down and actually understand the subject that's important, not only to that lobbyist, but frankly, more importantly to the principal. Remember, there's over 1,400 principals, and yes, we can probably all give you a pretty good idea of what Excel is lobbying on, but there are 1,400 principals. There are a lot that we don't really know very much about. And then lastly, on the legislative lobbying, again, we're moving away from telling us how much they spent on their phone bill to listing the top 4 specific issues that they lobbied on. So if they were lobbying on charter schools, they would list charter schools. That's the sort of information that we want. And the point there is that we can then index that. And so that if you're coming to our website and you say, okay, it's important to me on charter schools. That's an important issue to me. So I want to be able to say what entities, what associations are also lobbying on charter schools. You'd be able to put that in, and then the database would be able to say the following 45 principals, I don't know the number, but the following 45 principals are lobbying on charter schools. And you'd be able to do that for any significant subject before the legislature. I think, and the board believes, that that would, for the first time, really be moving us to a point where the lobbying program goes from, to be blunt, a program where we're spending state resources on disclosure that doesn't get us anywhere, to spending the same resources, because I'm not asking for a budget increase to do this, for disclosure that I think will provide information to the public. And frankly, to you as public officials, you would also be able to go and say, well, this is a new issue, who's working on this, and be able to see a list from our website. We do have, this is new, we do have a problem with our definition. 2 years ago, there was a change. I'm sorry, let me step back and quickly explain that currently you're a lobbyist, again, I think I mentioned this, if you're paid over $3,000 for communicating with public officials. The definition was changed and it went into effect on January 1st to say that you're also a lobbyist if you're paid over $3,000 from a business whose primary source of revenue is from government relations or government affairs services between 2 third parties. Well, the problem is that includes administrative people. If I'm working in IT for a business that does that type of thing, I may never talk to a public official in my life, but I'm paid over $3,000. I think the literal reading here is that person should register as a lobbyist. From our perspective, that's muddying the water. Now we have people registered as a lobbyist who in fact are not lobbyists, and that doesn't help allow the public to understand who they should be, who really are lobbyists. So I'm not sure exactly how we're going to fix that problem. It also relates to a change in Chapter 3 that affects only members of the legislature. We're trying not to adversely affect those provisions, but we are going to work here to try to come up with language that will reduce the scope of that change so that we're not registering people who, frankly, simply are not communicating with public officials and in the board's view are not lobbyists. And I think that's it. So happy to take any questions.
Thank you. Any questions from the committee? Senator Marty.
Mr. Chair,
Thank you. Mr. Sigurdson, on the lobbyist disclosure, I've always wondered, because we require them to report how much they spend on postage, telephone and telegraph. I mean, that's a dated list, obviously, but it's small incidental things. And then you mention in here about how the total amount spent on lobbying is like $74 million. I wondered why the merit of perhaps, instead of requiring the report the little disbursements, basically how much is going through any particular lobbyist on behalf of a certain thing. If I'm lobbying on behalf of entity X, might it not be appropriate to say that between what I'd be filing in my report might say what I and my firm or my business is spending total, in other words, we're compensated for, including all our salaries, all of our expenses, all the other people. When you mentioned how somebody who might be doing some IT work that might be listed as a lobbyist, instead of trying to track all that, shouldn't the reporting lobbyist perhaps say, we put $100,000 into lobbying on this issue, whether that counts in salaries or postage or whatever? Might that not be much more useful than knowing how much they spend on subscriptions and on postage and travel and so on?
Mr. Sigurdson.
Mr. Chair, Senator Marty, I think the board would agree with you. What I probably didn't make clear is that part of the lobbying proposal is to totally eliminate the reporting of cell phone and telegraph and postage, just get rid of it. It's a bit of a trade-off, frankly. We don't want to have a disclosure program that's unduly burdensome, and we're sincere when we say that. I mean, the right to petition government is, in fact, something that lobbyists should be able to do. We're not trying to make a program here that bogs them down and so they have a difficult time reporting. So we're getting rid of all of that minor, what we believe is unimportant disclosure, and focusing on the subjects. Now, we still receive the cumulative amount spent by an association from the principal. The principal also files reports, and that's a different issue. Here, we're requiring more disclosure. Currently, I didn't go into this because it's a little bit into the weeds, but the principal currently is required to report within the closest $20,000. In other words, they get the round to the nearest 20,000. This reduces it to the $10,000, which is actually the federal standard. If you can report for $10,000 for the federal government, I think you can do that in Minnesota. We require the principal in the proposal to provide specific information on what's called grassroots lobbying, where they do advertisements saying, contact your legislator and ask them to vote yes or no on whatever issue. The principal will have to provide detail on that type of expenditure. And the principal also has to break down between those programs, PUC, legislative, metropolitan, and administrative lobbying, how much they spend on each. And that includes the salary that the compensation that they're paying their lobbyists, whether they be contract or in-house. So we are getting that number, but we're getting it from the principal instead of the lobbyist.
Mr. Chairman, Mr. Sigurdson, that's helpful. I'm glad you're tightening up a little bit. Again, getting rid of the postage and travel types of things is trivial in a sense. But I also think in addition to the principal reporting, they spent, I mean, some of the larger principals may spend $1 million types of lobbying things. If they have 10 lobbyists, 2 of those lobbyists might be responsible for 9/10 of it. One of them might be just a small incidental thing. And just simply, if they were required within even the same $10,000 range to report how much they were, in effect, devoting to it. In other words, if they have a $100,000 contract, they could say within the $20,000 range that that's how much they are spending, whether it's that individual lobbyist or one of their staff members doing it or something else. But it seems to me that the difference between somebody who's spending $1,000 and somebody who's spending $100,000 on lobbying might be important perspective in the same way, knowing what interest is doing it, also who is involved in it that much. And I don't think it gets that much personal detail about how much somebody's paid or something, but at least would be ballpark of how much somebody's spending to lobby on something.
Mr. Sigurdson.
Mr. Chair, Senator Marty, in a way, I guess I'm still maintaining that in a way we're getting that information. The majority of lobbying expenditures And again, we do have this issue of grassroots lobbying where they're doing advertisements through the media. But frankly, that's not most principals. Again, we have 1,400 principals. Most of them aren't doing their lobbying through public advertisement or campaigns. They're doing it by hiring a lobbyist. So the expenditures that they're providing really comes down to compensation because the cell phone bill, again, is almost nothing. And if you're rounding to the nearest 10,000, you know, a $200 cell phone bill doesn't do it. So really, you know, I would suggest that you can still make the comparison between, and maybe this is not the point you're trying to make, but if the point is that the public may want to know that this entity is bringing $1 million budget to the table, and this entity which opposes it is bringing a $50,000 budget to the table, that information is being provided. You're right, we don't ask them to provide information on anyone's individual salary, even within a range, partially because, partially because in working with the MGRC, I think they view that as looking at, and I'm forgetting the correct term, not a corporate secret, but a trade practice that, because a lot of this, remember, is contract lobbyists, and there is very much a competitive market there, and they're concerned about if their individual salaries start getting out there, that becomes an advantage to people who are bidding against them, and so that's their concern there. They don't have any problem with the cumulative amount being paid reported by the principal. That's been the case for years. But breaking it down by individual lobbyists, I think they would have a concern with.
Mr. Chair, not wanting to prolong this much more, but one more point, and that is, I think, in addition to knowing that entity X is spending $1 million to influence legislative or administrative or whatever type of action, knowing that of the 3 entities they're hiring for that, one of them may be basically their lobbyists and the others are just incidental ones. I think having a scope of this is not intrusive of private stuff, and it's of the public interest to know who is really playing a role in these issues. And I know because we've had some folks, we had some who were lobbying for one entity, contract lobbyists were lobbying for other ones too, and they'd always focus, I lobby for this and this and this, and they'd hardly mention one, and that one may have been 99% of their business. I just think that its interest, the public right to know should include not just from the principal, but also from the lobbyist. And anyhow, I'll leave it at that because you've said what you were saying, and I think that's worth exploring further. But the other one I wanted to ask quickly, if Mr. Chair, and this is not on the, it's on the economic disclosure, is it still the case that on our forms, if we disclose, we have to disclose if we're an officer or where we have a tie with a business, but we still have an exception here. If you're an independent contractor or consultant, you don't have to report anything. Is that correct?
Mr. Sigurdsson.
Mr. Chair, Senator Marty, no, there is information. If you have a contracting business, you now have to provide information on that business. So there is additional information that has to be provided for contracting.
So, Mr. Chairman, to be
Senator
clear,
Marty.
if I were contracting with your business or something, I would have to just, independent contractor or a consultant, I would have to report that now, because in the past you didn't have to, I believe.
Mr. Sigurdsson.
Mr. Chair, Senator Marty, you're correct, or I believe that's correct. I'm trying to recall the year that was changed, but there was a recognition that consulting was not being disclosed. I would have to get back to you on the exact year that occurred, but there is more information on consulting.
Thank you.
Follow up? Any other questions? Thank you, sir.
Mr. Chair, if I may state one last thing. These are proposals. I'm going to have them jacketed. If there's any member here who's interested in any of these proposals, I would love to hear about them.
Thank you. Thank you. I'm sure there's lots of people here that are interested. Bipartisanly. Any other questions of the chair for today? We are at the end of our planned agenda here. Our next hearing will be Thursday. And at this point, we have some issues that we are looking at, but it might be a little premature because we're waiting for some things to be forwarded from other committees. We only have right now 5 bills that have been sent to us. And I think there's a couple that are in competition to be the first ones that we hear. So pay attention to your notices, and we'll be getting back on Thursday again at 3 o'clock. So I'm going to adjourn the meeting for today. Thank you.